At 7:34 a.m., 6 Federal Justice Bureau agents arrived at the diplomatic residence complex with Executive Authorization Directive 18, Delta authorizing immediate questioning of Ambassador Victoria Anderson of the Northern Coalition regarding alleged prohibited financial transactions. At 7:37 a.m., the lead agent presented the directive at the residence entrance. At 7:41 a.m., Ambassador Anderson appeared and formally invoked diplomatic immunity under Protocol 47 of the Vienna Convention, stating on camera, "I am a diplomatic representative. I hold full immunity from your jurisdiction under international law. I will not submit to questioning." At 7:43 a.m., the agent contacted the Justice Bureau's International Law Division. The division stated diplomatic immunity is absolute and questioning a protected official without waiver violates international law, adding that proceeding could expose agents to personal liability. At 7:47 a.m., that guidance was transmitted to the executive's office with a formal legal warning. At 7:52 a.m., the executive's counsel responded the directive stands, that national security emergencies create exceptions and questioning will proceed. The response included a legal memorandum arguing the Vienna Convention does not prevent sovereign nations from protecting vital security interests when foreign officials engage in ongoing criminal conduct. At 7:54 a.m., agents entered Ambassador Anderson's residence. The ambassador stated, "You are violating international law. I invoke my immunity and refuse all cooperation." For 43 minutes, agents posed questions about financial transactions. Ambassador Anderson sat silently, stating only, "I invoke immunity," after each question. Subscribe to this channel immediately because what you are witnessing is not a law enforcement operation. This is a constitutional and international law crisis where the executive has ordered federal agents to question a foreign ambassador who holds absolute diplomatic immunity. This is agents executing an order that their own legal counsel states violates the Vienna Convention. This is the Northern Coalition, government demanding immediate cessation and threatening to withdraw diplomatic recognition. And this is the question of whether Executive National Security Authority can override treaty obligations that have governed international relations for 70 years. Turn on notifications because the next 24 hours will determine whether the executive's directive stands, whether agents continue questioning despite immunity, whether our diplomatic treaties survive this confrontation, and whether allied governments maintain recognition when we violate the foundational principle of diplomatic inviolability. Here is what led to this moment. For 8 months, federal investigators tracked financial flows between the Northern Coalition's government and prohibited entities. Intelligence reported Ambassador Anderson personally facilitated transfers totaling $47 million in currency. The Justice Bureau concluded probable cause existed, but the International Law Division issued binding opinion that diplomatic immunity prevents any law enforcement action. The opinion cited Vienna Convention Article 29, stating diplomats are inviolable and may not be arrested, detained, or questioned. But here is where it shifted. 72 hours ago, the executive convened the National Security Council. Sources report the executive stated allowing a foreign ambassador to violate our laws undermines sovereignty, and that diplomatic immunity was not intended to shield criminal conduct. The Executive's counsel argued the Vienna Convention includes implicit national security exceptions. The foreign minister objected, stating violating immunity would trigger international backlash. The Justice Bureau director expressed concerns about retaliation against our ambassadors abroad. At 11:47 p.m. 2 nights ago, the executive signed Executive Authorization Directive 18 Delta, stating Ambassador Anderson poses ongoing threat to national security, and that questioning is necessary. The directive cited Article 8 of our National Security Act, granting the executive authority to take necessary measures during emergencies. The directive ordered immediate questioning, but did not reference diplomatic immunity or the Vienna Convention. Now watch what happens next. At 6:47 a.m. this morning, the Justice Bureau's director briefed agents, stating the executive issued a lawful order. When asked about immunity, the director said the executive's counsel determined immunity does not apply under national security provisions. At 7:12 a.m., the International Law Division sent urgent memo stating no such exception exists, that questioning violates international law and agents could be personally liable. At 7:23 a.m., 6 agents departed for the diplomatic residence complex. At 7:34 a.m., they arrived. Ambassador Anderson immediately invoked immunity and contacted the Northern Coalition's foreign ministry at 7:39 a.m. The coalition demanded immediate cessation, stating this violates the Vienna Convention and threatening to recall their ambassador and suspend relations if questioning proceeds. At 7:54 a.m., agents entered the residence and began questioning. Ambassador Anderson stated repeatedly she invokes diplomatic immunity and refuses to participate. Agents continued asking questions about financial transactions. Questioning lasted 43 minutes. At 8:37 a.m., agents concluded and departed. No documents were seized. Drop a comment right now. Tell me whether the executive has authority to order questioning of a diplomat protected by absolute immunity, or whether this action violates international law. I am reading every response because this is the question every legal scholar, foreign ministry, and allied government is confronting at this moment. At 8:52 a.m., the Northern Coalition recalled Ambassador Anderson and suspended all diplomatic relations, stating our government cannot be trusted to respect international law. At 9:14 a.m., 3 allied governments expressed serious concern about the breach. AT 9:37 a.m. The legislature's Foreign Affairs Committee held emergency session. The chair stated the action may have violated the Vienna Convention, which is federal law under Article 6. A resolution calling for apology and investigation was introduced. At 10:23 a.m., the legislature voted 41-34 to pass it. At 10:47 a.m., the executive rejected the resolution, stating the legislature has no authority to direct executive foreign policy or national security operations, and that protecting the nation from sanctions violations is a core executive function. At 11:04 a.m., the Justice Bureau director stated agents acted on lawful orders and followed proper procedures. At 11:34 a.m., the International Diplomatic Court announced emergency proceedings on whether our government violated immunity. The court stated if violation is found, our nation could face international sanctions and potential exclusion from multilateral forums. At 11:47 a.m., 5 additional nations announced they were reviewing diplomatic presence pending resolution. At 12:14 p.m., our ambassadors in foreign capitals reported host governments questioning whether our diplomats enjoy full immunity given our actions. 3 ambassadors received warnings that if we do not reaffirm Vienna Convention commitment, host nations may consider our diplomats' immunity void. At 12:29 p.m., the Foreign Ministry attempted clarification stating we respect immunity, but exceptional circumstances may require limited questioning. The statement was rejected by the Northern Coalition and allied governments as insufficient. There is a detail most people missed. Vienna Convention Article 29 states diplomats are inviolable and shall not be liable to any form of arrest or detention. Article 31 grants immunity from criminal jurisdiction. The convention includes no exceptions for national security. The only way to question a diplomat is if the sending state waives immunity. The coalition has not waived and explicitly refuses. Our executive ordered questioning anyway, arguing domestic security authority overrides treaty restrictions. But our Constitution's Article 6 states treaties are supreme law. At 1:04 p.m., the Superior Tribunal was petitioned for emergency ruling on whether the directive violated the Constitution by breaching treaty law. The tribunal declined, stating treaty interpretation is a political matter for the executive and legislature. At 1:37 p.m., the Northern Coalition announced consultation with other signatories about collective responses. This is the moment it stopped being a bilateral diplomatic dispute and became a systemic challenge to international legal order. At 2:03 p.m., 14 nations issued joint statements saying Vienna protections are absolute and not subject to unilateral exceptions. The statement called for acknowledgement, apology, and compliance commitment. Warning of reciprocal actions and potential collective withdrawal of recognition at 2:34 p.m. The executive responded that our government stands by its actions and national security will not be compromised by rigid treaty interpretations. 8:47 p.m., 3 allied nations recalled their ambassadors for consultations expressing grave concern about apparent departure from established diplomatic norms at 3:14 p.m. legal scholars issued a joint warning that the precedent could encourage other nations to claim national security exceptions, leading to widespread violations. At 3:29 p.m., reports emerged that two nations were preparing to question our ambassadors, citing our precedent. Here are the indicators we are watching. Does the executive issue acknowledgement or apology? Does the legislature take stronger action? Does the Justice Bureau director resign or break with the executive? Do more nations recall ambassadors? Does the international court rule against us? Do nations question or detain our ambassadors in retaliation? Does the Vienna framework begin collapsing? Here are the three scenarios. Scenario 1, the executive reverses course, facing international isolation and threats to our diplomats. The executive acknowledges questioning was inconsistent with Vienna protections. An apology is issued to the Northern Coalition. The coalition restores diplomatic relations. Allied nations welcome de-escalation. The International Diplomatic Court closes proceedings. The international framework holds, though trust is damaged. This is the treaty compliance scenario. Scenario 2, the dispute remains unresolved. The executive maintains the action was lawful under national security doctrine. The coalition refuses to restore relations. Allied nations remain concerned, but maintain diplomatic ties with us. Our diplomats face increased scrutiny, but no retaliatory violations. The International Court issues a non-binding advisory opinion. The system operates under uncertainty about immunity exceptions. This is the ambiguity scenario. Scenario 3, the Vienna framework fractures. Multiple nations cite our precedent to justify security exceptions. Reciprocal violations multiply. Our ambassadors are questioned in foreign capitals about alleged intelligence activities, with host nations citing our precedent. Diplomatic relations deteriorate globally. The 70-year consensus on absolute immunity collapses. This is the systemic breakdown scenario. The Vienna Convention has governed diplomatic relations since adoption. 193 nations are signatories. Violations have been rare and usually by nations with weak rule of law. This is the first time a major democratic nation with strong legal institutions has ordered law enforcement action against a diplomat, invoking immunity, and justified it through domestic national security law. What I know for certain right now at 7:34 a.m., federal agents arrived with executive directive. At 7:41 a.m., immunity was invoked at 7:52 a.m. The executive ordered questioning to proceed. At 7:54 a.m., agents questioned despite immunity. At 8:52 a.m., the coalition suspended relations. At 10:23 a.m., the legislature called for apology. At 10:47 a.m., the executive rejected it. At 2:03 p.m., 14 nations issued joint warning. At 2:34 p.m., the executive defended the action. The Vienna Convention grants absolute immunity. Our Constitution makes treaties supreme law. The executive claims security authority overrides both. The coalition has withdrawn. Allied nations are reconsidering presence. Our ambassadors face potential retaliation, and there is no mechanism for resolving whether executive domestic authority can nullify treaty-based diplomatic protection. The question is whether international legal frameworks survive when major powers assert unilateral exceptions at 4:17 p.m. The Federal Diplomatic Legal Archive recorded the following entry: executive authorization directive executed, diplomatic immunity invoked and overridden, Vienna Convention compliance disputed, international framework stability uncertain. And whether the next entry records restoration of treaty compliance or systemic collapse will determine whether the foundational principle of diplomatic inviolability can withstand the assertion that national security permits any government to breach any treaty at any time.